Let me ask you something. Have you ever had a client make you regret saying yes to the deal? Maybe they blew past boundaries, disappeared on payments, or worse, they started threatening chargebacks, lawsuits, or trashing your name online. You're not alone. I've seen this way too often. And it's not just a bad personality. It's a legal vulnerability in your business structure. Hey friends, today's episode is a little different. You're about to watch a special live training webinar I gave called Copy My Contracts and System to Avoid Client Nightmares. It's all about the toxic client problem, which is one of the most overlooked threats in your business. So in this valuable webinar, you're going to learn the 5 types of toxic clients that creep into coaching, freelancing, and service businesses. Number 2, the legal and structural mistakes that let them in. And number 3, how to bulletproof your boundaries using contracts, SOPs, and red flag filters that I've developed over the last 20 years as a battle-tested lawyer. And best of all, you get to copy my system, copy my contracts, copy my SOPs to start legally bulletproofing your client agreements, and you'll see how much better your client relationships will become. So I promise you, once you see these patterns, you'll never unsee them. And you won't get this training anywhere else. So let's dive right in. So here are the rules of the game that I've learned over the course of 20 years. Number 1, all entrepreneurs have 5 enemies and 101 deadly mistakes that they're exposed to. I call this the losing recipe. I put that together over years and years of data and research based on my own clients, other cases, myself. Now, clients are one of those enemies. They're one of the 5. And there's at least 5 client types, the toxic traits that you really need to watch out for. And the good news is you can avoid these clients. You can avoid these toxic traits. You can avoid these mistakes with the right SOPs and the right contract, the right strategy. So let's get into that, because I've learned that being an entrepreneur, there really isn't a winning recipe. There's no winning recipe to copy. Sure, there's characteristics of successful entrepreneurs that you can emulate, but there is no winning recipe, and I've tried to find it. But what I've learned as the attorney is there is a losing recipe, and the winning recipe is basically avoiding losing, avoiding your enemies, avoiding your mistakes. So let's get really into it. So what's missing that every entrepreneur needs, but they don't even know they need? Number 1, it's a defense. Most entrepreneurs play offense. That means they focus on branding, sales, and marketing literally 95% of the time, and they ignore their defense. They ignore setting up the structures, strategies, and systems in place to protect themselves from business threats, right? Number 2, they lack a system to identify their threats and eliminate them. Entrepreneurs have systems when it comes to funnels and emails and sales, and they know all that, and there's plenty of materials to teach them that, but they don't have defensive systems, legal systems, and that's got to change. Number 3, most entrepreneurs don't have a client dispute process and SOPs that helps them set the right boundaries that's meant to resolve client disputes before they become real issues and liabilities. Big businesses use this, but entrepreneurs like you don't have access to it. You don't have the money to pay lawyers to create it, and you don't have an in-house compliance team. Number 4 is most entrepreneurs don't have customized, legally bulletproof contracts that they even understand or know how to modify. And number 5, most importantly, most entrepreneurs don't have a relationship with an experienced business attorney who can be their mentor, who they can call before they make the decision, before they sign the deal. It's all about preventing your mistakes. That's why I want you to copy my system. I want you to learn how to think like a lawyer. I want you to literally take my SOPs and contracts and change yours tomorrow. So let's talk about what you're going to learn here today. Number 1, you're going to learn how to think and write like a battle-tested lawyer, not like a normal lawyer. I'm a battle-tested lawyer, and I'll tell you why shortly. You're also going to have to learn about the losing recipe, and that's basically the 5 enemies and 101 deadly mistakes that cause entrepreneurs like you to lose. And that comes from the thousands of mistakes that I've seen made by myself, my clients, people I've worked with, and other cases that I've diluted into this system. And number 3, you're going to learn how to identify and eliminate the 5 toxic clients and the mistakes associated with them. Number 4, you're going to get my exact contract terms, my exact SOP terms, my exact system. Number 5, you're going to get to see my business defense system, how I put it together, how I think,
And it's going to be, I promise you, much different than any other webinar, any other workshop you've ever attended, because this is an offensive workshop. This is all about defense. It's all about protecting you. It's all about avoiding mistakes so you can learn from the mistakes of others. That's from Warren Buffett, a guy I admire, just like Charlie Munger, Alex Hormozi. A lot of my techniques are based on these gurus but applied to the law. And that's why I think you're going to find it very valuable. So why listen to me? First off, I'm the only person who's actually talking about this and telling you this, and everybody else is hiding it from you, or they really don't know. Number two, I want to prevent your problems as your mentor. I don't want to profit from your problems as your lawyer. And there's a big distinction, and that's what I think makes me very different. Now, I'm a 20-year business attorney as well as an entrepreneur. I started my own practice, and I have extensive experience in what I would call the danger zones that entrepreneurs play with. Those are all the legal areas. And I also understand the mindset and the skills they need to win. Now, I've drafted, reviewed, and argued thousands of contract terms in court and in business deals. Most lawyers can't say that they've drafted contracts and actually argued them in court. They can't say their contracts are proven or that they really know what goes on in court. I can. I've litigated fraud, IP theft, business disputes, client disputes, partnership disputes, marketing and ad violations. I've litigated breach of contracts. I've nearly seen it all. I've set up businesses. I've done transactional work. That's where this system comes from. It's all the mistakes. It's all the enemies I've seen distilled into a system that you can truly benefit from without the pain and scars and crazy lawyer bills that my clients had to pay. So like I said, learn from the thousands of mistakes that I have seen intimately that I've put into this business defense system. That's literally the only business defense system designed for entrepreneurs by an entrepreneur. The whole goal is to make you and your business legally bulletproof with me as your mentor. And that's why I want you to copy this. Copy the contracts, copy the system, copy the SOPs. I'm going to show them to you. You ready? Let's go. Mistake number one is the never satisfied client, I call them. They're the scope creeper. They ask for more and more without paying. Now, it's not really their fault. It's your fault. And I'm going to explain to you why. The mistake that you made with this particular client who wants you to do everything for them is that you didn't establish boundaries and you're letting them request more and more. Now, you're giving this client free labor, services that are outside of what you promised. There's going to be resentment. You're going to have ruined relationships, and without the proper scope, the court's going to blame you. And I'll tell you why the court's going to blame you, because you, as a service provider, provide the contract to the client, and if anything's missing or it's not clear, the court is required to interpret the contract against you because you're the one who drafted the contract. So this is one of the biggest mistakes. They want the services you promised them, but then they want more services because you forgot to exclude services in your scope or whatever, and now you've got a really bad relationship. So the fix here is to have a tight scope of work, and any change orders have to be in writing, signed by both parties, and there has to be additional fees, right? If your client wants you to do additional services, you got to charge them more money, and they'll respect you for that. So the SOP to deal with this, the scope creeper we call them, is to set proper boundaries from the onset, to have the out-of-scope script starting with a phase one email. But the tip here is you got to make sure you not only include the services you're providing, but you exclude it, right? So let's look at my contract that I use. This is the kind of agreement I use to provide for my clients. And like I said, it's built upon 20 years of knowledge. The mistakes I've seen in litigation, I've reverse engineered things to put them in these contracts that most lawyers have no clue about. They don't know how to do it. And I'm going to show it to you, and I want you to copy this, screenshot it, copy everything. So scope of services. This is like number one. You got to put this right in your contract. Now, there's two ways to do it. You can write this into the contract itself, or you can attach this as a proposal. So the first sentence of your contract provision that you need, provider agrees to deliver professional services specifically described in the attached proposal, scope of work, or other written documentation incorporated herein by reference. That's what I would suggest you do, because you're going to use a generic contract, not a bulletproof contract, but it's going to be generic for you and your business. And then you're going to add, depending on the client and the scope of work, a different document that's going to be your proposal, scope of work, and it's going to be attached to this master contract. And this language incorporates it together and makes this together a contract for services. You get it? It's a formality, but people have used in court to nullify an attachment that hasn't been incorporated by reference. Now, in this scope of services, here, what you see is the services that you're actually here to provide: business or executive coaching, brand strategy, messaging, and positioning, marketing or advertising management. This is where you want to be specific. These are the services that I provide. And like I said, I would attach it in a different scope, but I wanted to put it here for you to visualize it, right? Now, maybe just as important, if not maybe more important, is what you don't provide, right? These are exclusions, just to be safe. Legal services, legal advice, or contract draft, and I'm sure you don't do that. That's the stuff I do. Accounting, tax preparation. You always want to put stuff like that if you're dealing with people who are, maybe you're handling their finance in some way, just because those are areas that can get really fuzzy. So media buying, advertising spend. You never know what's in your client's head, and that's why it's very important to have that conversation ahead of time to say, this is what I do, and this is what's excluded. And this happens all the time. So best practices: exclude services, right? Include services up top, exclude them here. And then you want a provision in here. Take a screenshot so you see it. You want a provision here that says that any change orders has to be approved in writing by both parties, and it may be billed at additional rates, right? And this is important. This is really important because you want to set the stage so you don't have any misunderstandings. They're toxic. And if you enable them and you don't have the right scope, they're going to take advantage of you, and you're going to end up in court, and you're going to lose money, and you're going to lose time, and we don't want any of that. We want to prevent all this. And you can do this. You can use my contracts and SOPs. So in the event that there's any conflict between the proposed work and the terms of this agreement, the terms of the attached proposal are going to govern. That's important because sometimes if you're using this contract and you want to modify deal by deal, you want to use that attached scope. And anything that changes in that attached scope, if it's in conflict with the master agreement, that term's going to control if there's ever an issue and dispute. And that's important because it's that term that you want to control, because that's why you're modifying the contract. Get it? Now, like I told you, if you don't have the proper scope, it's your fault. And the court is going to blame you. And I'm going to explain to you why they're going to blame you. And this is something that you learn in litigation. This is something most attorneys don't know about. And this is something that you really need to know because it's important. As a service provider, you're giving people contracts. So if your contracts are bad, vague, they're missing, the burden's on you when you go to court to prove things. So if your contract's deficient in any way, the judge, because it's you who wrote the contract, they're going to interpret the contract against you. It's a legal rule called the presumption against the drafter. The point is, I have a provision here, and it's very important in your agreement, and you won't see them a lot, that says this agreement has been reviewed by the parties who have had the opportunity for counsel or review same. These terms and conditions have been negotiated and agreed to. The parties agree that in the event of a dispute, the presumption against the drafter rule shall not apply. So that's telling the judge that, both parties got to look at this agreement. Both parties had the opportunity to have lawyers, and they could have negotiated it, and the court's not going to apply the presumption against the drafter. And this is great for you. I want to show you in an SOP how we kind of deal with the scope issue. Here are what I call the best practice manual. All of you entrepreneurs have to have one of these. It'll systemize your defense, like I said. It'll help you keep things on track. Now, this is very important because this client practice manual is going to show you, here are the 10 most common client mistakes and the risk they create, right? Here is the toxic client, the scope creep, the defamer, the ghost blamer. We're going to get into these 5 right here, but here's 5 more. There's total 10 at least. And I'm just showing you this SOP that you can copy, right? So here's the issue. Here's the escalation timeline. Here's the final action. This is a whole process on dealing with a client behavioral problem, an issue, and how to resolve it short of litigation in a friendly manner up until you have to assert some legal muscles that you can do on your own, trained properly, and that's what this is about. So you're going to see my SOPs, contracts together. They make up your defense system along with strategies and other things, right? So this is what I've created. There's a 4-phase escalation process that deals with the emails you send to a client when you start to have issues with them. And I break it down in 4 phases. This is the main process that you need to know that works legally. There's reasons behind it. That's the key. So here what you want to do is use an IRAC analysis framework. I set out the issue, the rule for you, and the analysis. Let me just show you how the phases work, right? So let's say the client is late with a payment. Phase 1 is a friendly reminder. Hey, you're late with payment. You know what's going on. Phase 2 is formal notice of breach. Hey, by the way, you're in breach of the contract now. Payment has to be here at this point. Phase 3 notice. Now we're talking about a couple weeks later. Hey, by the way, I've now suspended services. So now you're protected. You don't have to work for free anymore. And you can start to invoke damages and reasonable efforts to resolve, right? That's required by law before you end up in court. So we go into phase 4, communication, which is a final demand. This is like what you send before you really get the lawyers involved. So that's the process I've created with templates. So here's the rule with the scope creep. This client only gets the services that are in the scope of work clause. And if you're going to change anything, there has to be a clause for additional fees, right? So the solution here, when the client's asking for more things, before it becomes a legal problem, is to send them a phase 1 notice and propose a change order for more fees in writing. And if there's no response, you then send them a phase 2 notice that says that you're suspending your service pending their response, because the point is you don't want to do more work for them. You don't want this to turn into a legal issue. So here's the template that you should copy, right? Hey client, thanks for your request. I want to touch base to ensure we're aligned on the scope of our work per our agreement. The included support covers. And this is where you want to be detailed, because this starts the documentation. You may have to go to court or whatever. You need a documenting system. It's all part of defense. So requests beyond this can absolutely be added as part of a custom add-on retainer. Now you're saying, hey, I can do the added services, but it's going to cost you more money. If you don't want to do the added service, say these services are not included, period. That's how you handle the scope creeper initially. If there's no response or they insist, we escalate to phase 2 with the formal notice. Then we escalate to phase 3. We suspend service. And I'll show you how this kind of works all together. But that's the process. So let's get out of scope. Now, do you see how having a tight scope of work can save you from client nightmares? Do you see how just the knowledge of your enemies' mistakes are helping you become more confident about your business? Do you see how this entire system can bring you the peace of mind you need as an entrepreneur to know you're protected, right? Because you're focusing on sales, marketing, branding. That's what we all do. There's so much stuff to do in business. It's almost impossible to do it all, and that's why you can't do it all. So let's go into mistake number 2. That's called the defamer, the client who trashes you publicly. Now, we don't want any of this. And the reason why we don't want any of this, because this really hurts your brand. Now, who's at fault here? Again, it's on you, the entrepreneur, because you didn't set the rules so that the client understands what's going to happen if he posts anything negative or she posts anything negative. So because you didn't set the rules, clients now are expressing dissatisfaction with you all over the internet, bad-mouthing you. They're writing bad reviews that aren't even justified. So what do you do here? What's the risk? The risk is brand damage, lost trust, loss of clients, and without protecting yourself here, it's going to be difficult for you to prove any damages in court, right? Because if someone goes after your reputation and disparages you, writes bad stuff about you online, negative reviews, you have to prove the damage that was done in court. You don't just go to court and ask for $1 million. You got to show through experts and testimony and evidence and P&L statements and forensic accountants how much money was lost, and you have to tie it to causation and the brand dilution. It's very complicated. It's a very hard to prove in court. Most people don't realize that, and they think they're going to walk in with millions. That's why you need liquidated damages. Liquidated damages is a provision, again, most lawyers don't even think about because they're not in court. Court's all about 2 things, liability and damages. So if you can get them out of the way through contracts and establish liability and damages on paper, agreed to by the other side, you've hit a grand slam. You haven't hit a home run, you hit a grand slam. So how do we stop that client from bad-mouthing you everywhere? We need a non-disparagement clause in the contract, right? We need a liquidated damage provision in the contract. And then we need a survival provision that says that this provision, non-disparagement, survives the contract, meaning if our contract ends in a year and I go badmouth you in 2 years, my obligation under the contract that's expired still exists. You can go after me. But if this obligation dies with the contract and then a year later I disparage you, you don't have a cause of action. That's why you need survival terms inside the contract to protect you. Let's not get into all that. But if you want to ask me questions about litigation, I love to explain the courtroom to entrepreneurs. That's a value I give to you, and that's why my system's proven, because I actually know what happens over there. And the more you know what happens there, you can protect yourself in business. Now, how do we deal with the client who defames you? What's the SOP, right? The SOP here is we don't send them the friendly reminder. We send them the phase 2 escalation notice. We send them a cease and desist template to shift the legal burden. And we want to remind them of liquidated damages plus attorney fees, right? Because this person is tarnishing your reputation publicly. So we don't need to send them a friendly reminder. We need to establish, hey, you're on notice of a breach. This is the breach. If you don't stop this or remove this, we're going to have to take a legal action. So you're ordered to stop this, and if you don't, we got to go to court. I'm seeking liquidated damages, and you'll be responsible for attorney fees. So let's take a look at this non-disparagement provision now. Here we go. So the parties agree that during the term of this agreement, following its termination, they shall not, directly or indirectly, that's important, make or encourage any statement, comment, review, post, or communication that is false, misleading, critical, negative, or disparaging about the other party, their services, employees, officers, business practices, or reputation. Now, I think it's important to go on to detail. People write these generally, and it's not very good, because if you ever have to go to court, the other attorney wants to argue that whatever the client is saying is excluded here. It's not covered by this non-disparagement provision. So I try to make the provision as broad and detailed as possible. There's an art to it. It takes years of drafting, years of being in court. That's why I wanted to copy this. There's a reason why it's written this way, and copy it. This prohibition applies in both public and private communication channels. That's important, including but not limited to social media posts or comments. And then we go on. Client acknowledges that reputation is a material asset of the provider's business and agrees that any such communications, even after termination, right, may cause significant harm and irreparable harm. Irreparable harm is a legal term. It's important because it helps to get you to court quickly. The parties agree that breach of this clause shall be considered a material breach and shall entitle the non-breaching party to injunctive relief. That means that you can go to court and stop this person from bad-mouthing you, and recovery of monetary damages. That means you can get paid. And C, liquidated damages as per the provisions in this agreement. So that's what the client now is exposed to, and that's pretty scary, right? And so let's go into liquidated damages just so you can see what this looks like. I know this might be a little boring for you, but it's much better than being in court. You don't want to see your business go down, and I'd be happy to make this more fun. So I want to go into liquidated damages now. This is 10F, right? Here's what liquidated damages is. In the event of a breach involving confidential information, intellectual property, or non-disparagement, client agrees to pay liquidated damages to provider in the amount of 3 times the total fees paid or owed under this agreement, or $10,000 for each breach, whichever is greater, on top of damages provider may prove. This amount represents a reasonable pre-estimate of harm suffered by a provider due to the difficulty of quantifying reputational damage, loss of future business, or misuse of proprietary content. Now, those are very important, right? If the client agrees that this is reasonable, that's an issue we don't have to litigate in court, and that's an issue that you can litigate for hundreds of thousands of dollars for years. So what is reasonable liquidated damages, right? So now we say that both parties agree it's reasonable. Here's where this applies. It's not for everything. It's for these violations. And why? Because it's hard to prove reputational loss with certainty. So this takes that out of your hands. And now you have a certain amount, which is $10,000 for each such breach, or whatever the payment the client's made to you. That's reasonable, because if you put a crazy number here, the judge is not going to enforce it. I'll be honest with you. I put $10,000. That seems pretty reasonable. Really depends on the service you're providing. Is your service providing $5, or is your service $1 million service? Your liquidated damage amount should be reasonable to the service and to the potential damage. You want this in here. It's leverage. It's teeth. They're great. Liquidated damages are the best thing in court, because what do judges like the most? Exact numbers that are easy, decisions that are easy, because they don't want you in the courtroom. They want to have lunch. They want to get you out. So we're done with liquidated damages. We're going to go to attorney fees. So if I got to take action to enforce this agreement because you're disparaging me, you know what? You're going to pay for my lawyer fees. Now, Provision 11, which you take a picture of, says that if either party initiates legal action, arbitration, or any formal proceeding, then the prevailing party shall be entitled to recover money. Now, that's what's typical. You'll see that most legal Zoom contracts, Rocket Lawyer, all that stuff. You'll see that everywhere. Those are the most common. Prevailing. What does prevailing mean? You know what? You'll never get attorney fees with this provision. Trust me. I've been in court, argued them, this and that. You'll never get attorney fees because you can't prove what's prevailing. Most cases don't go to trial to get a win. You know, they get settled. And when they get settled, your attorney fees don't get paid. You know what I mean? So this is just kind of nonsense, if you ask me. That's my personal opinion. That's why I use a different attorney fee provision, and I have optional ones that you can choose because I have a customized proprietary system and method that I make these contracts. They get customized to your business and stuff like that, and that's why I want you to copy them. Here's my alternative, right? This is provider favored. This is for you, and this is in the event that the client breaches this agreement and fails to cure such breach following reasonable notice and opportunity to resolve the matter informally, and provider is required to initiate enforcement actions to recover amounts owed or to compel performance. The client shall be responsible for all reasonable costs incurred by provider in connection with such enforcement. Now, this is a loaded paragraph, and the reason why is because we're saying we gave the client reasonable notice, an opportunity to resolve informally. We gave them all that stuff. And the provider now is still required to go after the client. So you know what, Judge? You got to have that client pay our attorney fees. Now, this includes, but it's not limited to, attorney fees and legal expenses, costs of demand letters, and pre-litigation communications. That means even the legal work that's necessary to be done prior to filing a lawsuit, you're saying here, and they're agreeing to it, that they have to pay that in case you have to enforce this agreement. Arbitration, collection agency, all this stuff. Post-judgment interest, post-judgment collection. And have any of you experienced hiring litigation attorneys, you know this number could be thousands and thousands of dollars, years of litigation, and you might be on the hook for paying someone else's attorney, including your own. That's horrible. So, like I said, this is great leverage. This is what you want in your contract. Take a screenshot. We're going to go over to the SOP right now. So someone defames you. They're bad-mouthing you on the internet. This is assuming that they're still your client. If they're not your client, you don't have to say we're suspending service, but this is what I mean. You're not sending them a friendly reminder. You're sending them a phase 3. I'm suspending your service, or you've breached. I'm invoking damages and reasonable efforts to resolve. So if I go to these templated scenarios, right, here's the defamer. Dear client, we've been made aware of statements that may be considered disparaging under our agreement. We ask that this behavior stop immediately to avoid escalation. We also ask that you remove the statement from the wherever it is within 5 days of this notice. In the event you fail to comply, we will be forced to escalate this matter and seek penalties under our agreement, which includes but is not limited to attorney fees, costs, and third-party indemnification. So third-party indemnification is something I'm going to get into later, but that's basically saying that if I have to go after somebody else because of what you did here, because of your disparagement, then you're going to have to pay for my fees, and you're going to have to enforce that for me. It's very powerful. So let's get back into the presentation here. Bad client mistake number 3, the ghost blamer. This is the client who disappears. They don't cooperate. And you know what? When they don't get the results that you promised them, that dream outcome that you painted, they're going to blame you. They're not going to blame themselves. And that's the toxic client who's the ghost blamer. But the mistake really is on you because you didn't set the rules and the client stops responding. You don't have the SOPs, you don't have the contracts, right? So here's your risk. Timeline delays, refund requests, bad results, and it's going to be all your fault. And if you don't have the proper documents and contracts when they go to court, the judge is going to blame you. Again, why? The burden's on you to prove that it was the bad client. The burden's on you because you drafted the contract, right? So how do we fix this ghost blamer is putting the obligation of actively participating, being cooperative, responsive on the client, putting the obligation of the outcome and the results on the client, despite what you might have sold them on. The obligation has to be on the client, right? So we need to have a tight client responsibility section. We need to have a suspension clause, which I've been talking about, because if that client disappears, he's not responsive, you need to suspend your service so you're not obligated to perform more services. It also requires you to have a payment authorization provision in your contract that allows you to charge them based on the agreement they made, even if you can't get a hold of them. You need a results disclaimer. This is how you make your offers legally bulletproof. You need to disclaim your irresistible offers and your dream outcomes and limit your liability. These are all very important provisions. We're going to dive into them. And then with the SOP, you need to initiate phase 1 unresponsive client email, and you go through phase 1, phase 2, phase 3. Listen, you don't need to jump the gun with these people. Maybe they disappeared for a second. We're all busy. But the point is this, you can't sit on this, and the sooner you deal with this, the better. We're here to prevent the mistakes before they become liabilities, right? So the whole point here is if they ghost you, you should pause immediately, right? You don't refund, and make sure to shift the blame for the lack of results immediately to the client, because that's going to be their next move. They're going to start complaining that they want a refund, and then the bad mouthing starts, and this is why we have this system, right? So let's go into the contract really quick. This is a very important provision. Client responsibilities, right? I'm not going to read these word for word, but there's a reason why it's written like this. I'd like you to take a picture of it. I'm sorry it doesn't come fully on the screen, but you get the picture. So here's what it's all about. This basically says that the client has to timely communicate, and we're specific, 5 business days, right? They got to give you access to materials. They have to actively participate. The information they give you has to be accurate. The client has to acknowledge that the success of the services is dependent upon client's engagement, timely cooperation, and the application of deliverables or recommendations. Provider doesn't guarantee any particular outcome where client fails to participate or execute agreed upon actions. That's very important. Now, here's the delay and suspension rights. So if you delay, I can't find you, I can suspend my services. Why do I continue to work for free without you? Maybe you're gone, maybe you ghosted me, who knows? So we do that in a friendly way because, like I said, we're not here to jump the gun, but we need to move on, and we can't let these problems become liabilities. So not only do we have strict client responsibilities under this agreement, I want to show you something that's also just as important, especially important in court. And a lot of times lawyers don't understand this because they haven't gotten to court. They don't know what happens in court. Court's all about damages and liability. That's it. My whole thing is to prevent court. I don't want you in court. I don't want you hiring lawyers to go to court. Limitation of liability. Here we go. To the fullest extent permitted by law, client agrees that the provider's total aggregate liability for any claims, damages, losses, or liabilities arising out of or related to this agreement shall not exceed the total amount actually paid by the client to the provider under this agreement. Under no circumstance shall provider be liable for any indirect, incidental, special, consequential, punitive, or exemplary damages, including but not limited to loss of income, revenue, or profits, lost business opportunities, client dissatisfaction, reputational harm, emotional distress, business interruption or delay, or any such other loss. Now, the reason why all these words are in here is because these are all scenarios that have happened. These are all things that have been litigated, arguments people bring up that cost business loss, that cost you a lot of money, pain, and suffering. So this is an amazing provision. You need this. Take a picture of it. It's got to be in there. The whole point of this is if we have an issue, client takes me to court, the only thing I'm really exposed to as a provider is what the client paid me. That's my maximum exposure based on this provision. And it's written very well. I believe it holds up. This is proven. I've been in court. We've argued this issue. You'll see them all day long in these consumer contracts you sign on the internet. The boxes, I agree to terms and conditions that are 60 pages on the internet, and you've somehow reviewed it in 2 seconds and click that box. You're probably agreeing to a limitation of liability for sure. And the whole point of this is it caps your exposure to what the client paid you. So if the client paid you $5, give them back the $5, and they got no claim for damages. If the client paid you $1,000, give them back the $1,000, and they have no claim for damages. If the client paid you $10,000, pay them back the $10,000. So that's an easy way to resolve disputes, just like that. Let's move on. So because this one is so important, I put the entire burden of results on them, and that's something where there's a tension between, I think, the offensive coaches, the gurus, the marketing salespeople, and the lawyers. Right? Because sales, you're promising dream outcomes. You're painting a vivid picture. You want to promise them the world. You're showing them all sorts of crazy testimonial success stories that may or may not be true, okay? And that's a whole separate thing that we're going to get into eventually. But the whole point is this. As the lawyer, I'm pulling back and saying, whoa, listen. You can paint all this for them, but they need to understand that this doesn't always happen. This can be exceptional, and this only happens if the client cooperates and the client does these things and the client follows through and the client. You see how I'm shifting the picture and the dream outcome over to the client. So it's their burden to get the results, not you, because when they don't, they're going to point it at you and they're going to say, you didn't coach me, I didn't make the money you promised me, it was because your system sucked, whatever. But you're going to say, no. You agreed that you had to participate. You understood that you had to put in all these efforts, and you didn't do that. So here's why this is important. I'm going to read a little of this word for word because we kind of need it. So the client acknowledges and agrees that while provider may, from time to time, reference or display testimonials, case studies, performance metrics, or illustrative examples related to results of other clients or businesses, such references do not constitute guarantees, warranties, or representations of expected outcomes. Each person's story, facts, and outcome are different and varied. The client understands that all such examples are illustrative in nature and are intended solely to demonstrate potential, not promise performance. The success or outcome of the services provided on this agreement may vary significantly based on numerous factors, including but not limited to clients' personal and professional efforts, consistency and quality of implementation, responsiveness. Provider expressly disclaims any and all express or implied warranties regarding the results of the services, including without limitation any implied warranties of merchantability, fitness for a particular purpose, or non-infringement. Whoa, those are legal terms. You don't really need to know them. I'm telling you what they mean. These are warranties that are excluded, that are required by law, that whatever they're selling is fit for the purpose that they're selling it. Let's not get into all this stuff, but basically this is saying, hey, you're buying a service from me with no guarantees. Just take a picture of it, use it, please. Like I said, copy my SOPs, copy my contracts. They're there to help you prevent these problems, mistakes. I'm sick of seeing entrepreneurs lose. And that's what I think the majority of you lose. You don't lose in sales and marketing. You understand that. You have coaches for that. You have materials for that. You have scripts for that. You have systems for that. You lose in defense. You lose in legal structure. You lose in not understanding business deals, not understanding marketing compliance laws. You lose in not understanding how to structure businesses. You lose in not understanding how to protect yourself. You lose in not having a lawyer. You lose in not having SOPs. You lose in not having this system. Like I said, defense wins championships. And you can see how provisions like this would really save you from a client nightmare, right? This would really save you from a major lawsuit. It would save you probably from a fraud case. Have any of you guys experienced this? I'd love to hear your feedback because I've seen this over and over and it's horrible to go through, and you need to learn from the mistakes of others, and that's what this is all about. So you don't experience the pain and scars that they did. So that's the ghost blamer. Let's go right into the template that we would send out here. Just so you can see it, take a quick picture in the SOP. Here you go. Ghost blamer. We have been trying to reach you, but we have not received a response from you, right? We're still phase one. We can't jump the gun and think they're gone and blaming us already, okay? I don't want you to start thinking that crazy, but we're getting there. I got to look at the cup half empty. You can look at it as half full. So we've been trying to reach out to you, but we haven't received a response from you. We hope everything's okay. If we don't receive a response within 7 business days, we will suspend our services as per our contract. That's fair, right? That's not written in a mean way. This may impact your results. Oh, it sure will. Please review the client responsibilities and result disclaimers set forth in our contract. Please contact us as soon as you get this notice. Right there, you're giving them notice. That's what you need by law. You're setting the stage. You're taking reasonable steps. You're doing everything perfectly. Right? So that's what you got to do with the ghost blamer. Let's jump into chargebacks. Here we go, the chargebacker. The chargebacker is somebody who's a little sneaky, and they're going to file a chargeback, meaning they're going to try to get their payment back by a credit card. They're not happy for their service, whatever the reason is, and they don't tell you about it, right? And they file a chargeback. I'm sure you guys have experienced this, and it's horrible. You lose the income. There's a risk that the platform may ban you if you get a bunch of these, and then you get brand harm. So the problem with this is you didn't set the rules and you let the client reverse payment with no warning. So what I do in my contracts, I have a chargeback clause. It makes chargebacks without notice unauthorized, which is important. And it makes it a breach, which is also important, because if you can establish that you've got a breach of the contract, you as the provider can now exercise leverage. You can suspend services. You can start sending notices. You can take all the reasonable steps you need to take to start protecting your business, because now this client is toxic and this client is an enemy. And how do we deal with them? We use our system. So in your SOP, when you're onboarding, the email has to talk about you have to contact us before filing any chargebacks, right? So the burden's on you. Like I said, the court's going to blame you if you don't have this in your SOPs and you don't have this in your contract. So let's take a look at this, how we stop the chargebacker. All right, so we're going to go right into, let's go into the SOP first, and then I'll show you the contract since it's right here for us. So here's what the template says. We've received notice of a chargeback on your payment of whatever. As outlined in our signed agreement, all disputes must be submitted in writing and are subject to a 5-day resolution period before any outside action. Filing a chargeback without notice is a breach of the agreement and may trigger additional legal and recovery costs. Please reply within 3 business days to resolve this directly. In the meantime, we are exercising our right to suspend services pending cure of your breach. That's powerful. Right? And it's really important that you clarify that from the get-go to avoid this problem. So now that you've seen the chargeback SOP, let's go right into the contract that I use. And here's the chargeback provision. I like to put it in the refund policy and dispute resolution provision, and you can customize this. Like I said, I have a proprietary method you can use, but this provision's great. You need this in your agreement. Copy it now. And here's what it says. The client agrees not to initiate any chargeback, reversal, or third-party dispute without first notifying provider in writing and allowing 5 business days to resolve the issue in good faith. Unwarranted chargebacks shall constitute a material breach of the agreement, and they may result in immediate termination, forfeiture of access, and legal action. Now you've given them fair notice that if they do an unauthorized chargeback, it's a breach, and you got 5 days to resolve whatever issue before they file a chargeback. This will save you a lot of time and headache. Put this provision in. Make sure you use it. And this goes into a refund policy, which is something you all should have one way or the other. And that's it with chargebacks. We've discussed a bunch of other provisions that relate to it. And now I really want to take a deep dive into the worst kind of client. Bad client number 5, the most toxic, the dishonest client, the thief, basically. The client that uses, steals, or resells your IP without authorization. This probably could be the worst one, but the problem with the dishonest client, it's kind of your fault. And like I said, the court's going to blame you. You're not going to be able to prove your case. You're going to lose this one if you don't have the right SOPs and contracts in place. And we're talking about your assets, your IP. This is extremely important. This is one of the deadliest, most toxic clients. Your mistake was letting the client use your system, and now they claim that they own your IP and they're reselling it without authorization. Like I said, if you don't have the proper contract, it's going to be extremely hard for you to prove your case or win. And the judge is going to blame you. The burden is on you. So the risk here is brand erosion, unfair competition, loss of revenue. You'll have to prove liability and damages, and that's not easy. It's going to cost you a lot of money. You don't want to be there. So what's the fix here? And remember, I've litigated IP cases. I've litigated cases trying to protect people's trademarks and IP, and I've litigated cases where they've alleged my client has infringed upon theirs. So it gets really ugly. It's very expensive. I want to get into it, but the whole point of this is to avoid all of it, right? So you need to have really airtight, bulletproof IP ownership clauses with no sub-licensing. You're basically licensing what you're producing to the client, right? So if you have a white label work-for-hire arrangement, then have the provision there with the proper payment. Have a liquidated damage provision in there. We run over that, right? So if someone violates this provision, liquidated damages apply. And I'm not going to go over that again. Have the indemnification for third-party protection and attorney fees. I'm going to talk a little bit more about that because that's important. So your SOP, when somebody steals, resells your IP, does something improper with your IP, has to clarify what license that you gave them. And you have to send an unauthorized use notice with an indemnification trigger and a cease and desist letter to them, as well as to any third party. And you're going to have to also follow it up with a DMCA takedown notice. Sounds all complicated. Take a picture. You know, funnels are more complicated, and you know how to do them. Like I said, you need a system for defense, same way you need a system for offense. But you can see how this systematic approach to defending yourself against bad clients can actually prevent legal issues, right? You see how this can bring you a lot more peace of mind and confidence and certainty, especially in your business where there is no certainty. Now, here's the deal. When you are hired as a service provider, you probably know this already. Some of you do, some of you don't, but you continue to make a mistake about it. Unless explicitly stated otherwise in writing, all intellectual property, proprietary materials, frameworks, creative assets, methods, systems, strategies, deliverables, those are things that I develop, like my system, developed by me prior to or during the engagement, shall remain my property. So if you're a service provider and you're providing clients with frameworks and creative assets, they're yours, right? And you're giving the client a license to use them. And the license is non-exclusive. You can give that license to anyone else. It's non-transferable. The client can't give it to someone else themselves. It's revocable, meaning I'm taking the license away tomorrow. And it's a limited license. It's only to use this particular creative asset for this particular reason, right? That's generally the arrangement. And then it goes on to say the license does not allow for reproduction, resale, sub-licensing, reverse engineering, blah, 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 blah. That's the typical arrangement. And what's very important here is this agreement does not constitute a transfer of ownership unless provider expressly agrees in writing and the client is paid in full and not otherwise in breach of this agreement. And C, here's the kicker, a formal written IP assignment of rights is executed by both parties. Now, that's a separate document, and it's very important to do it this way because without that signed written agreement, there is no transfer of ownership. So it creates one last condition which allows you to get paid in full, which allows you to get whatever condition met before you formally transfer ownership. Remember, once you transfer ownership of something, especially intellectual property, game over. Big problem. The only way we're unwinding that is going to court, claiming fraud through the inducement of the contract. It's hard. I've tried to do it. I've been in court defending this. Don't get involved in any of that. Don't make this mistake. This is a deadly mistake entrepreneurs make, whether sophisticated or not. And it's nothing to be embarrassed about. If you've ever made this mistake or experienced it, let me know if there's anything I can do to help. But that's basically it. So if you have a white label arrangement with the client, right, that means that the client may present the deliverables as their own in client-facing settings, only if expressly authorized in writing. Again, it has to be in writing, but they can't claim that they created the methodology or the IP. So you understand the difference, I'm sure, with white labeling. They can't say that they made the system or they're the ones who engineered it, but they can say it's their system to use. For example, that's what I can do for you. It's your system to use, but you didn't make the system. It's my system. It's my business defense system. I'm the only attorney who's made it, and that's a fact. And I have a very unique skill set and knowledge that allows me to be able to make a defense system like this because of my experience. So anyway, that's basically the IP provision. And there's customized options. I've just put these here for notes, but if you want to get contracts, I have a customized proprietary method where I ask you all these questions. Is it a white label situation? Is there full ownership? And if there is, you got to get paid in full, and then you execute an IP transfer of rights agreement. And that's like the work for hire situation. That's the best legal way to do it. That's the only way to do it, if you ask me. So the dishonest client decides to take, your IP and run with it. Well, remember, we have liquidated damages here. Boom, 10F. So that's leverage. We got to prove the damages. Then we have, like I told you, the indemnification. Now, indemnification is important because let's say the client gives the IP and your methods and frameworks to a competitor. Now you got to go after this competitor. You got to file expensive federal lawsuits and hire lawyers, right? Now, technically, the client who breached the agreement because they stole your IP has to indemnify you, meaning they have to hold you harmless, meaning they have to represent you, meaning they have to pay for your lawyers. That's how powerful indemnification is. It really protects you in situations where you have to go after people because of something that wasn't your fault. So you can see how having an indemnification provision in your contract that has some teeth like this can really save you from a nightmare. It can save you hundreds of thousands of dollars. It can save your entire business. You need these provisions, so take a picture of it. Now we're going to go into the attorney fee provision. We went over this. Same thing. You got leverage here in case you got to go to court, in case you're going to hire a lawyer to write demand letters, to go in front of arbitration, in case you have to hire a lawyer after you've gotten the judgment against them to enforce that judgment, because you don't get money in court. Most clients don't realize it. Entrepreneurs don't realize it. This is why I do what I do now, is because you don't get money in court. You get a piece of paper, then you got to go collect, and it's a nightmare. And that's why you really never win at the end of the day. You got to win in business. You got to prevent your mistakes, prevent your enemies, use my system, copy it. I don't want to see any more of you guys lose. That's the bottom line. Let me just show you real quick here what the SOPs look like when it comes to the dishonest client. Now, this one, you can go right at them. There's no need to be sending a friendly reminder when the client's dishonest and is a thief, right? And they're going to resell your IP. Now the client really is your enemy. and they could be a competitor. So now you got two enemies, not just the client, but the client competitor. Here's a template. Begin with the unauthorized use notice and request for them to take down before using the DMCA and cease and desist letters. So it says, listen, our agreement clearly states that the rights to use deliverables are contingent on full payment. So this is a situation where they got to pay you in full before you assign the rights to the IP. Payment hasn't been received. This is notice that your use of the deliverables is not authorized. Please make full payment within 5 days of receipt of this notice. A DMCA takedown request will be transmitted to third parties relating to any unauthorized action taken by you. That's a formal legal request to platforms to say, take down this IP. It's not authorized to be there. It's mine and it's not authorized. I have those. You can use them. If this matter is not cured within 5 business days, we'll be forced to move forward with a cease and desist letter. In addition, if you have provided our assets to a third party, you shall notify them that they're not authorized. And in the event we have to take action against them, you'll be responsible to indemnify us. So this is not a nice email or letter for them to get. And this is how you deal with that dishonest client. There's no friendly reminder here. All right. So we got that done. So those are the 5 worst toxic clients, I think, and the 5 big mistakes that are associated with those clients, the ones that you make that enable them. There's 5 other bad clients that I've seen and 5 other mistakes that are associated with them. We're not going to take a deep dive, but I just want to tell you, there's the breacher. That's the client who routinely breaks terms and ignores boundaries. There's the vanisher. The client who pays late, doesn't pay, and is not responsible. It's kind of like the ghost blamer, but they're a little different. It's more about late payments. There's the poacher. They're using your deliverables without payment, but it's unclear. They're not the thief. They don't have the bad intentions. It's just due to you having a lack of clarity, your contracts being vague or no contracts. Then there's the deal changer. There's always those, the clients who just tries to change the terms and the boundaries all the time. And then there's the never-ending client, just never satisfied. And you can't get rid of them because you don't have the right termination provision. Now, the reason I'm telling you this is for you to identify your enemies. And one of the 5 enemies are clients. And there's at least 10 toxic client traits with 10 mistakes that you make to enable those toxic clients. The top 5 we went into, there's 5 more here. And that's your battle against clients. Use my SOPs, use my contracts, use my system to prevent these enemies from taking you down like I've seen them take down so many entrepreneurs.
All right, and that's the playbook, the blueprint to how you legally bulletproof your client agreements and protect yourself against those toxic, nasty clients. Now you've seen exactly how toxic clients show up, why they get in, and how to lock the door with clear contracts, strong systems, and legal boundaries that actually hold, and how to avoid the mistakes that you make to enable them. Now, this is no theory. It's a system I engineered based on real patterns I've seen after 20 years in courtrooms, contracts, and business deals. So now you have it, a breakdown of the 5 toxic client types to avoid, the exact mistakes that leave you exposed, and a clear defensive system that you can implement right away. Contracts, SOPs, and my system, you can copy it and do it all yourself. Now you can start identifying toxic clients to stay away from. You also need to start making sure that your social proof is legally compliant and bulletproof so it doesn't come back to get you down the road, because it's your social proof that leads to the big sale. It's also the same social proof that leads to the liability, and that's the next video I'm recommending. Click on the link below. It's how to legally bulletproof your social proof, and I'll see you there.